such an order would not have been issued, because it was known that if a person did not wish to go, could appeal that decision quite easily. There is not a single proof that anyone complained or appealed their decisions of transfer. However, there is a lot of evidence testifying to the fact that many VJ officers were persuaded to go to the VRS. However, it leads to a conclusion contrary to the conclusion of the OTP on the significant assistance provided by Perišić to the personnel centers in the provision of the officers' corps. When the personnel centers were formed, nothing changed in terms of the existing mechanism of persuasion to depart for the VRS and the SVK in the absence of any coercive measures that could be exercised. Have a look at P317. It is an instruction for coordination of the 17th of December 1993. I won't display it now. I will only provide references. In BCS, it is page 8, and in English, page 9. It concerns a period after the formation of the personnel centers, and the staffing levels are referred to. It is stated as follows. On the 8th and the 10th of December 1993, a total of 7 officers from the VJ responded, and an issue of shortage of younger officers' personnel is highlighted. Perhaps this may not be the most illustrative example, but let us have a look at something else. Let us look at P1020, which is General Čeleketić's report of the 10th of April, 1995. That is to say, 20 days in advance of the events in Zagreb. In BCS, it is page 4, in English 6.
Govori se o upućivanju starešina.
It has to do with the dispatching of officers. It reads, at the beginning of March 1995, so a year and a half following the establishment of the personnel centers, the personnel department of the 40th Personnel Center invited the commanding officers born in the territory of the former Socialist Republic of Croatia to discuss their volunteer deployment to the SVK. Out of 600 present officers, 112 stated in a survey that they would be willing to go. In further processing and preparations for the dispatching to the SVK, a final positive answer was provided by 66 officers. On the day of their departure, when the time came to board the buses, the officers started hesitating and changing their minds, so that only 30 commanding officers went to the SVK, in brackets 15 officers and 15 NCOs. General Perišić, at the 37th session of the SDC, which is P786 in June 1995, which is over 1.5 years following the formation of the personnel centers, repeated his proposal he had articulated as early as October 1993 that Mr. Harman made use of. He asked that those people truly be resubordinated to the SVK with all the corresponding consequences. Interpreters' correction, instead of resubordinated, it should be transferred. Why such things did not develop exactly as the OTP would wish you have? Well, the SDC again rejected his decision, which is something we can see in Exhibit
Dokazni predmet
P762. Could we please have it in English?
Dobro, ja ću ga pročitati.
Here it is. In the English version, page 5, item J. The Council did not accept the proposal of the main staff of the 40th Personnel Center that officers of the Army of Yugoslavia, subject to military service, be sent in the future to Republika Srpska as the service may require. The voluntary principle remains in effect. Therefore, in the summer of 1995, although the personnel centers had been in existence for over 1.5 years, they did not produce the effect the prosecution referred to when putting forth their thesis of significant assistance in the provision of the officers' corps. There are two conclusions you can draw from this, which are completely contrary to some of the theses of the OTP. The first one about the significant contribution in the commission of crime, which took place through the provision of the officer cadre, and two, that by virtue of the formation of the personnel centers, nothing really changed in the way that cadre was sent. I may add that there was no legal mechanism. That is to say, that the orders of transfer could not result in sanctions for anyone refusing to join the VRS. The prosecution asserted that by virtue of the formation of the personnel centers, the position of those officers was institutionalized. Those who, until that time, had joined the VRS and on an ad hoc basis and voluntarily, and it is asserted that they were members of the VJ, as could be seen through the documents put forth. In their view, the view of the prosecution, this amounted in the institutional approach of the transfer of officers to the SVK and the VRS, including those who had already been serving with those armies, as well as those who left subsequently. It is in paragraph 176 of their final brief. The same thesis becomes the crux of their thesis, that those officers were then introduced into the chain of command of the Army of Yugoslavia. It is very important for us to ascertain what the matter at hand indeed was, because of Article 7.3 and their thesis that they were part of the officers' cadre of the VJ. En route to your final conclusion, the OTP should have established whether they were indeed part of the chain of command of the VJ, and whether General Perišić was their superior, whether the relation of superior-subordinate existed. Even if they had been members of the VJ serving outside the VJ, they were no longer part of their chain of command. The army of the law of the Army of Yugoslavia, which is Exhibit 197, stipulates that precisely, and it was often referred to by the OTP. That law, which provides imperative decisions on the status of those serving outside the VJ, and I will address the specific paragraphs later on, is something that the OTP did not refer to. The law on the Army of Yugoslavia is quite precise in respect of the status and rights and obligations of those serving outside the VJ. They were definitely outside the chain of command of the Army of Yugoslavia under Article 802 of the law. They had the same rights and obligations as if they were members of the army, unless provided otherwise by the law. So what is essential for our analysis? Please bear with me.
Intervencija.
I have an intervention for the transcript. It should be Article 8, sub-article 2, or subparagraph 2.
Just before you proceed, listen. Is it 8 subparagraph 2 or 8T subparagraph 2? 80 subparagraph 2.
Član.
Article 8, paragraph 2.
Thank you, sir.
Zakon o vojsci Jugoslavije.
The law on the Army of Yugoslavia, Your Honors, has to do with the commanding officers serving outside the VJ, regulating their status in relation to their promotion, appointment to duty, transfer, and termination of service, defining that these aspects lay solely with the Minister of Defense. It was Article 158, referring to Article 152 of the law. The Army of Yugoslavia has no input, including the General Staff and its chief. You heard detailed testimony from Mr. Starčević at page 6969 about that topic, as well as Mr. Nikolić at page 10717. They personally enjoyed the status and had their personal experience based on that. If a VJ officer is serving outside the VJ, all of the aspects of his service were exclusively in the remit of those who were in charge of the armies where they served, not the VJ. That is stipulated by the law. What I said a moment ago, when I said unless stipulated otherwise by the law, we have in this example another binding provision. It has to do with the initiation of disciplinary procedure, which should take an important place in your conclusions. The Army of Yugoslavia is competent to initiate a disciplinary procedure only vis-à-vis those people who are within the chain of command of the Army of Yugoslavia.
In respect of the individuals who are outside of the chain of command of the Army of Yugoslavia, for instance, the law refers to the Ministry of Defense. Article 181 confers the sole responsibility for the initiation of a disciplinary procedure upon the Minister of Defense. In relation to the exhibits dealing with disciplinary proceedings, we will be discussing those in relation to 7.3. Now, since all the individuals we are interested in right here fall outside of the chain of command of the VJ, the evidence is compelling, Your Honours. In their final brief, the OTP referred to Mr. Starčević and his analysis of Article 33 of the instructions governing the work of personnel centers, P734. His testimony even gave rise to some questions from the bench. Those paragraphs, or rather, let me ask that we call up now Article 33, that same article in respect of which we heard the interpretation of the OTP. Let me just see what page it is. Yes, it's page 7 in English and page 10 in BCS.
Želim da vam skrenem pažnju na ovaj član, jer inače mislim da je za...
I would like to draw your attention to this article also because I think it's relevant in respect of some other issues. In keeping with service requirements, professional soldiers and civilian personnel sent or transferred to the KC may be returned, assigned or transferred, that's what it says, to Yugoslav Army units institutions with the consent or on the recommendation of the KC main staff. In our view, Your Honours, there is no dilemma in interpreting the language of this particular paragraph. In order for someone to return, one has to leave before that. But let's move on. The prosecution relies on another set of exhibits to prove that the officers of the personnel centers were members of the VJ. These are judgments of the regular courts and military courts, where certain officers were asked for some of their entitlements to be recognized. However, these judgments, in fact, support the position of the defense that they were outside of the VJ. In fact, that's what all the judgments assert. Yesterday, Mr. Harman, in his submissions, referred to Colonel Blagojević's judgment, which is P1073, I believe. I will not be calling it up now, but look at what the statement of reasons of the military court states, that Blagojević was outside of the VJ. In no uncertain terms, he was a member of the VJ out of service within the VJ. Now, as for this particular judgment and Dragomir Milošević's case, which was before a regular court and not a military court, so the claims made in respect of that must be taken with caution by their chambers. In those proceedings, no evidence was adduced with regard to the status of those individuals in, for instance, the VRS, as, for instance, D330 was never adduced in respect of Mr. Blagojević. That was the operational map of the Army of Republika Srpska. Or let's look at something else which will overturn the contention by the OTP. Can we now move into private session, please, and look at D120.
Do we have confirmation that those screens there are dead? Thank you.
We're back in open session, thank you.
Thank you so much. Yes, Mr. Lukic.
Dakle, odbrana tvrdi.
The defense argues that the officers defined by the OTP as members of the 30th and 40th personnel centers of the VJ General Staff, and I will continue using the term that I consider quite appropriate, which is virtual, so that they were holding virtual positions with the VJ while they were in reality with the VRS or SVK, were not actually members of the Army of Yugoslavia. Besides, it is the OTP themselves who admit that the officers were outside of the VJ at the time. In their final brief, they in fact support our thesis in several paragraphs. For instance, in paragraph 190, the prosecution states resolutely that General Perišić was able to transfer them back to the units of the VJ. In other words, to go back to where they were not by that point. And I will refer you to some other portions of the OTP brief where the OTP admits that they were not members of the Army of Yugoslavia in a period of time which is important for us. Can we have the break now, Your Honours? Because I would like to broach a new topic, albeit a similar one.
We'll take a break and come back at quarter to 11 for the jet.
Rise,